Hello viewers. Today we will discuss about an appeal against an asylum support decision. We will cover brief overview, apply to the tribunal, after you send your appeal, what happens at the hearing, get a decision, legislation and previous decisions. Brief overview. You can appeal to the first-tier tribunal, asylum support, if you've applied for asylum support and been turned down. You were claiming asylum support and it's been stopped. The tribunal must receive your appeal within 3 days of you getting the letter about the decision. You may be able to carry on claiming asylum support, if you were already getting it, while you appeal. The tribunal is independent of government. A judge will listen to both sides of the argument before making a decision. Help you can get. You may want to get help and advice before you appeal. Contact the Asylum Support Appeals Project for free advice and legal representation if you have an appeal at the first-tier tribunal, Asylum Support. You can contact British Red Cross, Refugee Action and Refugee Council for advice and support. They may be able to find another organisation near to you. You can also get other legal advice, including from a lawyer. Apply to the tribunal. Download and fill in a notice of appeal form. You must include why you're appealing, your grounds of appeal, a copy of the decision you're appealing against, any documents that help support your appeal, why your appeal is late, if it is, whether you'd like a paper or oral hearing. Paper hearings are based on documents only. If a judge decides that an oral hearing is required, it may be held by phone, video link or in person. If a judge decides you have to go to an oral hearing in person, you'll need to travel to London. The Home Office will pay for you to get there, usually by train. You'll get free accommodation the night before if you have far to travel. Send the form. Post, email or fax the notice of appeal form to HM Courts and Tribunals Service. The contact details are on the form. Call the helpline if you have any questions about completing the form. The helpline cannot give you legal advice. After you send your appeal, you'll normally find out within a week of sending the form whether the tribunal will consider your case, whether the tribunal needs more information, for example if your appeal was late. You'll then be told when your hearing will take place and whether it's paper or oral. If you have an oral hearing, you'll be told a few days before the hearing what documents to bring with you, or to send by post in advance. The letter will also tell you if the tribunal wants to call up any witnesses. You must contact them and make sure they appear at the hearing. You'll usually get the decision at the hearing. What happens at the hearing? What happens at the hearing depends on whether you have a paper or oral hearing. Paper hearing. You will not go to a paper hearing. A judge will make a decision based on your notice of appeal form, your documents provided by the Home Office. Oral hearing. Oral hearings may be held in person or via phone or video link. Oral hearing. If you or your witness or representative is outside the UK and wants to give live video or audio evidence, contact the tribunal to request it. Tell the tribunal what country you, the witness or representative is in, and what type of evidence is being given. You must do this as soon as possible. You'll present your case to the judge. Someone else can do this for you, for example a lawyer, friend or family member. The Home Office will present the case against you. The tribunal will provide you with an interpreter if you've asked for one. They can translate what happens during the tribunal, but they cannot represent you or give you legal advice. Oral hearing. You may be asked questions by your legal representative, if you have one, the Home Office's representative, the judge. The hearing is public. Family and friends can attend. If the hearing is in person, they'll have to pay their own travel costs unless they are witnesses. Children can only attend if you cannot make childcare arrangements. They can either wait in the waiting room with your family or friends, be with you during the hearing. Getting decision. You'll get the decision either at the oral hearing, if you have one. You'll also get full written reasons within 3 days. by post the day after the paper hearing. The judge will either allow the appeal, this means you'll either get asylum support or carry on getting it. Turn down, dismiss your appeal. Ask the Home Office to look at the decision again, known as remitting the appeal. The judge's decision is final, you cannot appeal again. You may be able to get a judicial review of the decision, if your appeal was turned down, and you think the judge did not follow the law correctly. Talk to a solicitor as soon as possible. You cannot complain about the decision, you can only complain about the tribunal staff, and the way the hearing took place. Legislation and previous decisions. Previous decisions. Search the decisions database to see how and why previous decisions have been made. Legislation. The tribunal will make a decision based on Immigration and Asylum Act 1999, Nationality, Immigration and Asylum Act 2002. The tribunal must follow the rules and process in the tribunal procedure, First-Tier Tribunal, Social Entitlement Chamber, Rules 2008, and amendments to the tribunal procedure, First-Tier Tribunal, Social Entitlement Chamber, Rules 2008. Failed asylum seekers. The tribunal will make a decision based on Section 4, Immigration and Asylum Act 1999, Immigration and Asylum Regulations 2005. If asylum support was stopped while the application was being considered, the tribunal will make a decision based on Section 95, Immigration and Asylum 1999, Asylum Support Regulations 2000. All related link has been mentioned in the description box. Thank you for watching.